It is Tuesday, March 16th, 2021. Still meeting remotely over YouTube and Zoom. This is Senate Judiciary. The subject this morning, the first subject is S3, which is currently in the Senate Appropriations Committee. So we got a late, I'll say late, it's not his fault, but an email with a letter from AJ Rubin, supervising attorney with Disability Rights Vermont, who wanted to comment on certain sections of the bill. So,
Mr.
yes, I'm sorry.
You might want to, for the benefit of people who are watching and don't know kind of how we work at this time of the year, we were scheduled to meet at 10:30, and you might just let them know why we're meeting not at 10:30, but later, so that they don't wonder if we met without being live.
Thank you. We did not meet without going live. We were on the floor late because of debate on an elections bill. And I'm proud that Vermont is, at least the Senate, is trying to make elections easier for people at a time when other states are trying to make it more difficult for people to vote. We appreciate the Senate Government Operations Committee and the amendment from Senator Benning, which took quite a bit of time to discuss. So that's why we're late. So please, AJ, go ahead. It's S3. We're anxious to hear your testimony.
And thanks to Peggy. I guess the agenda did say after the floor.
Yeah, we changed. Over the weekend, Peggy was good.
Oh.
We changed the agenda. Peggy was always good. She and I worked this weekend on the agenda as I got information from the pro tem about floor schedules. Thank you. Disability rights. You have a letter. I think it's posted March 11th, 2021. AJ, yes, please.
Thank you again for having me, AJ Rubin from Disability Rights Vermont. Want to say that the bill overall is really fits the need right now in terms of many of the aspects of it. The only thing I wanted to raise today with the committee is a concern about the section on reporting information about the status of someone on an order of non-hospitalization. That's on it's in section C on page 6 of 11 of the bill is passed by your committee. Just to briefly summarize the issues I think that the legislature should keep in mind when considering this is that I understand absolutely the need to assure the public, and especially victims of crime, that when someone is found not guilty by reason of insanity or not competent to stand trial, that person will not represent a danger to the victim or anybody else in the future. And that is why, if someone cannot be held criminally liable and punished, they must be considered to be placed in the custody of the Commissioner of Mental Health. And we as a society demand that the Commissioner of Mental Health make sure that person is kept safe. So there is a public safety aspect to that. So I understand that's an important value that we have. Concerns about this section of the law include that, as far as I can tell, no other close states, really no other states I could find, or the federal government, require the kind of information that is being requested to be reported. And again, the bill purports to require that if the commissioner becomes aware that the treatment plan is inadequate or the person's not complying, that they notify the prosecutor and the court of the criminal case, with I think the implied expectation that that person or entity might notify the victim. So as far as I can tell, no federal or state law allows that type of information to be disclosed. But what is clear is that when people leave custody or abscond, or they're not going to be under custody anymore, or they're moved from a lock setting to a non-lock setting, that type of information is generally disclosed and is not something that would put this law at risk of a legal challenge. This new stuff about the ONH information seems so unique that it lends itself to being questioned. I looked very carefully at the federal regulations involving HIPAA. There is an exception for judicial requirements, but even that exception requires things like giving the person notice that their information is being disclosed, giving them an opportunity to consent. You know, all those things are not part of this bill. So it leads me to think that that there's more research to be done on this small aspect. From a practical point of view, from a victim's point of view, I'm pretty sure that many victims would not want to be notified that the person who victimized them is not complying with their treatment plan, or maybe the treatment plan is not sufficient, because there's no teeth to that. That basically causes people anxiety to think, oh my God, maybe I'm at risk. There are laws in place now that if the designated agency who's doing this work, or the commissioner or anybody else, thinks the person is imminently dangerous, they can be picked up on an emergency exam evaluation, or the designated agency and the commissioner can file a motion to revoke the ONH. That happens when the professionals think there's a real danger and we have to act. But this middle ground that the bill seeks to focus on is very vague. So there's a concern from the victim's point of view, and I will reiterate that my office represents victims all over the state of Vermont, you know, victims of serious crime with disabilities. So I have feeling and experience in that realm. From another concern that we think the legislature should consider is the practicality of this. The law as it's currently written says that if the commissioner becomes aware, she or he or they have to report this. But there's no mechanism to become aware, and there's no requirement in the bill that the commissioner become aware. And I don't think that happens currently, because as you know, the designated agencies are the ones who do these orders in the community. And it's not clear to me that they're letting the commissioner know when there's a non-compliance with the treatment plan, which could be as simple as drinking beer once, or not coming to an appointment once, or could be really bad, but not the level of asking for an EE. So practically speaking, the logistics seem problematic. There's an issue about what the designated agencies and the people doing the therapy are going to feel like when they have to report to the commissioner if they do non-compliance. So there's a practical issue as well. I think that there is a legitimate problem with orders of non-hospitalization. There are 300 or so people, according to the Department of Mental Health, just in unofficial conversation, about 300 people on ONHs around the state. Most of them are not people who came through the criminal court system, I believe, but there's a lot of them. There's very little oversight of this, as far as I can tell. I was part of a committee a couple of years ago that the Department of Mental Health organized to discuss orders of non-hospitalization. I can tell you that there was a large faction of people on this 40-person or 30-person committee, large faction, who felt that we shouldn't have orders of non-hospitalization because they're so ineffective and they give everybody a false sense of security. So against that background, the problem is that if someone gets ordered into an ONH, the community has a right to think that we're safe, that person's under treatment. I would posit to you that a less legally fraught way of dealing with that need, that legitimate need, rather than have this sort of new groundbreaking law that requires this really strange notice under weird circumstances, vague circumstances. The best way to, I think, deal with this would be to require that the Department of Mental Health institute a practice that the Department of Aging and Independent Living has instituted recently. And that is this thing called a commissioner's warning. My understanding is that currently, and just recently, when the commissioner of DALE, Disability, Aging, and Independent Living, when they pay for someone to be funded for community placement in the community, if anybody who's part of that person's team, the Office of Public Guardian, a low-level service provider, an administrator, if anybody feels that person receiving DALE funds is at risk because they're not complying with their treatment plan, or the treatment is not adequate to their need, there is now an automatic way that they can not only just go to their supervisor, but go directly to the commissioner's office and say, hey, this is something that deserves more attention than we're getting through the normal chain of command. It's not enough to say EE or put this person away, but it alerts the commissioner and it puts them on notice that there's something more to be done. To me, that's what the problem-solving way to deal with this would be, not this sort of vague and fraught and kind of ineffective idea that if someone's not complying with their treatment plan, somehow the court.
How can you determine it's ineffective before it's even effective?
Well, you know, the people on the ground who are doing this work, I think they've got a good handle on it. This whole debate reminds me of the Kuklikowski tragedy, right?
Well, that's where it starts.
But this, you know, this bill on the ONH is not going to have an impact on that, because it's not clear the department would ever know that the person in that case was not taking their medication, nor is it clear that if they knew that they would, that alerting the court or the prosecutor would have any impact. You know, what needs to happen is the person either has to be determined so dangerous they could be taken off the street, or the power of the government has to be focused on making sure they get the right support so they're not anymore. And this is about community services. This is not about notifying people of things that are vague and maybe going to not be effective. So these are all things to consider. Again, I on behalf of DRBT and the people we represent around the state, we very much support the vast majority of this bill. It's a long time coming. This one little section seems fraught with problems, and there might be a better way to address the issues that are involved. And I think there's a possibility of legal challenge given my research on it. So those are the things I just wanted the committee to be aware of. And I am grateful for the time.
I appreciate that. I wanted to give some time, since this draft language basically came from the Attorney General and the state's attorneys. I wonder if they have any comment. David?
Good morning, Senator. David Chair with the Attorney General's office, for the record. I think Attorney Rubin certainly correctly identifies the problem we're trying to solve, and I think has a clear understanding of it, which is that there are times when people who were defendants, and under this statute, a case will remain pending in order for this to happen, there are serious concerns about that individual and about public safety problems that they may pose, either generally or to a particular victim. And there's been frustration among prosecutors, generally, both state's attorneys and our office, around not being able to learn information about what may or may not be happening with that person. And a sense that some more information sharing there could be helpful. I certainly acknowledge, and this is something we discussed, that the mechanism proposed may not be perfect. It may not get all information. We understand that there are going to be decisions made by designated agencies and clinical providers around what information may or may not be shared with DMH. And understand, of course, that there is a potential remedy solely on the family court side of things, where a order of non-hospitalization could be reworked or changed to an order of hospitalization if it's not working. So I understand that there are potential alternative mechanisms and there are imperfections in the proposal here. With respect to the Hipaa issue, I will acknowledge here, not being an expert on that, we did discuss it a bit with legislative counsel, and I will let them make representations about their read of this. My understanding is that they felt comfortable advising this committee that the proposals were within the law. But again, I don't want to speak for them, and I frankly rely on their representations on this as well. But I have reviewed the case that they were talking about, and it certainly seems to me that they are on solid ground on the basis of the relevant case they're working with. all that being said, our proposal, our belief rather, is that what we have is an imperfect proposal that's better than nothing. That at least has a fairly strong argument that it is, or you know, a decent good faith argument that we're within HIPAA regulations. And I would also note that there is a longer term, that we really envision this as being a stopgap. It may ultimately be an imperfect stopgap. It may be one where not all information that prosecutors would like to get is received. But it is a stopgap that will hopefully that will help a bit and take us through to a period where the forensic working group comes up with a much more comprehensive change to the laws and how Vermont deals with these issues, which I think there is broad agreement is overdue. And that's where we stand on it. Appreciate Attorney Rubin's concern. I think they're reasonable concerns, but our belief is that it is perhaps an imperfect solution, but one that we hope will provide a little bit more information that can be helpful to prosecutors and protecting public safety. And we will ultimately, we hope in the next few years, turn towards a more comprehensive solution.
Appreciate that. That's helpful to me. Pepper, did you want to comment?
For the record, James Pepper, Department of State Attorneys and Sheriffs. I don't have much to add to what Attorney Scher just noted. I mean, we did struggle with this section, especially kind of what AJ Rubin was talking about. What is the kind of next step once the notice has been given? We think that this will dovetail nicely with the work of the forensic working group, and hopefully this will help provide a little bit more information to the prosecutors when people are not voluntarily complying with their orders of non-hospitalization.
I want to say that this comes on the heels of either Saturday or Sunday. I received a call from a constituent after the Bennington Banner ran an article about this bill, and that had gotten the impression that Mr. Pronto, who's the alleged perpetrator in the crime in Bennington that the witness talked about, had been released. And I told him that wasn't true, that the bill did try to deal with that if he were released, but that he wasn't released. But I think many times the general public sees the use of this mental health system as a way of avoiding responsibility for the actions in a particular, particularly some of the high in a criminal activity. And the lack of I'm glad you brought up the lack of a forensic response in Vermont. I think that is ultimately the solution. Senator White.
So I just want to make sure that I understand. We're not talking about the 300 people who are on ONHs. We're only talking about those who are on ONH because they entered through the criminal system, right? Criminal justice system. And then I just want to make sure what AJ is saying, if the part that you're particularly opposed to is the section that says that if the treatment is not working or is not sufficient. And I have some sympathy with that because I'm not sure. I think that is so subjective on the part of the agency that's providing the treatment or the worker. So is that the section particularly that you're opposed to, or is it that whole section?
So thank you for the question. And to be clear, I'm not lobbying either way for the bill. So I wouldn't say I'm opposed to it. From a lawyer point of view, and in my position, it looks to me like an employment opportunity for me, right? So I think the small section of that bill that says that the department has to, when it becomes aware, tell other people about somebody's progress in treatment, that looks like it clearly violates HIPAA, because I've done the research, and despite Ledge counsel, it doesn't seem, if it doesn't provide for notice and an opportunity to consent, it's going to be a violation of that section. Also, it's not effective. So it just seems that there is a real problem, and there should be a real solution. And this small part of the bill seems like it's going to cause more harm than good. So I think it should have more consideration. That's what I'm suggesting.
So it's that part only, but the part that refers to absconding and stuff, that is fine.
Yes, and
Yeah,
the reason
okay.
it's fine is because most other jurisdictions have that law, and the federal government has that law. So it has been determined to be something that's acceptable, whereas this thing, as far as I can tell, is unique.
Yeah, that's what I thought. I just wanted to make it clear that that's what you were objecting to. I would suggest that we actually take out that one line, and that the committee commission or council or whatever we're calling it comes back with a recommendation after doing more research.
Could you be more specific as to the line?
Yeah, I don't have the bill right here in front of me, but it's the one that there's a couple different reasons there. One is if the person absconds, and one is if the treatment is not working or not sufficient. That line that addresses the treatment not working or not sufficient. Eric probably has it right in front of him.
So it's on page 6, lines 12 through 20.
Okay.
But Senator White, there's two different provisions there that regarding notice. One is about person not complying with the ONH, and the other is about alternative treatment not being adequate to meet the person's
Right,
treatment.
both of those.
So those are the two,
Yeah,
I think, pieces you're referring to.
exactly. Thank you.
I should note two things there, and I think Attorney Scher would probably have the cross-reference better. But I believe that is based on a current statute that requires notice when the court notices either one of these two circumstances coming into play when a person is on an ONH. But that doesn't require, the current statute doesn't require notice to the state's attorney or the AG. I think it's just the court in order to probably reconsider what the plan ought to be. And the last piece on the HIPAA point is that we're actually looking at a different exception than the one that Attorney Rubin mentioned. It's the required by law exemption. It's the one where we feel comfortable that if the legislature decides to mandate in law that information be disclosed, that would comply with that particular exemption to HIPAA. And we've found a couple of cases on that seem to support our reading. I agree with Attorney Rubin that under the other exemption he mentioned, it would not qualify, but we're looking at a different one. Again, not that it couldn't be argued the other way. And obviously that's something that the courts might have to look at if the litigation came forward. But we at least feel like there's authority for the legislation as it is.
Okay. I'm unable to find the section that you're proposing to strike. Could you read it, please?
It's Senator Sears. It's as was mentioned, it's on page 6, lines 12 through 20. It's subdivision C, capital C.
Okay. As used in this subdivision, victim has the same meaning.
No, starts just below that line, subdivision C, right after that. When a person has been committed under this section.
Okay, yep. And is subject to a non-hospitalization order.
Correct. This is the piece that's separate from the victim notification. This is a separate notification requirement one specifically applies when a person is already in the community on an ONH. So they're already in the community on the order of non-hospitalization. And one of these two things happens. If you look at Roman numeral 1 and 2, either the person is not complying with the order or the alternative treatment has not been adequate to meet the person's needs. If either one of those circumstances are discovered by the commissioner, then the commissioner has to provide notice about that to the state's attorney or the AG's office.
But that's at the heart of the, let me go back. It seems to me that that's the heart of the whole issue that we were trying to solve. I'll go back to the original February 22nd. The Emily Hannum case highlights these significant issues. Her killer was charged with false information in February of 2015, sent to a reparative board where he completed in July of 2015. A few months later, in October of 2015, he's charged with domestic assault, placed on probation with mental health conditions in February of 2016. You're supposed to work with United Counseling Service. United Counseling Service does not share information from my agency in any cases, not just this one. Within months, this is from Erica Marthage. Within months, he violated his probation, was brought back to court, given stricter probation conditions, again focused on mental health with United Counseling Service. A year later, he violates his probation. Again, he's placed on probation with mental health conditions, requiring him to work with designated mental health agency, UCS. He violates again within a month, and now his defense attorneys start to argue competency. During 2018, submitted to the state hospital, DMH is entered as a party to the criminal proceeding. State's attorney's office does not receive any information from DMH. In fact, we are told we're not entitled to the information. We cannot tell his victim at that time anything about his whereabouts. Again, in 2018, the defendant is found not competent. The state attorney's office requests a hospitalization hearing. DMH intervenes as a party. Here's where the frustration comes from. DMH is not recommending hospitalization. DMH controls the only potential witnesses. The doctors at the hospital and the state's attorneys are not entitled to any of the information from the state hospital. We have nothing to offer to support an order of hospitalization and need to withdraw our request. As we know from above, an order requiring him to work with UCS, United Counseling Service, has no value for him and has not prevented further criminal activity. Law enforcement interacts with him a few more times for threatening the neighbors, but again, law enforcement has no tools to assist in determining his level of dangerousness. Criminal defendants with mental health issues that have been through the system are aware there's little we'll be able to do. Significant issues within the current system. And that's when we get on to, and that's the reason for this, in my opinion, section and why it's necessary to have. I think if you then look at February of 2021, he murders, actually January, allegedly murders, and I think the evidence of guilt is great, murders a young lady at 11:05 a.m. in downtown Bennington by slitting her throat. That's this guy, and that's the history that's presented, and that's why we're trying to change the law. And I think if we can't give that information to, I agree that maybe the forensics committee will come up with a better solution, but people are dying, people are not safe. No. AJ?
Thank you for the opportunity. It's a tragic outcome. And again, I see this, all over the state. And it does happen. It just seems like the way to fix the problem is to increase the supports and the capacity in the community so that when someone like that starts getting out of control, there is a response to it. And again, this idea that if the commissioner becomes aware and they even tell State's Attorney Marthage that the person's not complying, there's no way that's going to translate to more public safety. That will just add to more concern, which might translate to more funding for community supports, which would support the problem, but it seems like a backwards way at trying to address an important problem. And I want to just reiterate that I have done the research on the section of HIPAA that Legs Counsel Eric Fitzpatrick is discussing, and I'm pretty confident that the law doesn't mean that any state law is okay to disclose protected.
We've already passed the bill out of committee, and I'm getting. I'm not going to get into the HIPAA argument here.
Understood.
Because I think I'm trusting our legislative counsel. On the other hand, this issue of removing, Senator White has proposed removing this, and that's why I would oppose it till we have a better solution to somehow. Karen Barber, do you have a thought?
I do. I just wanted to clarify something, Senator Sears. For the record, Karen Barber, General Counsel for DMH. Being on probation and having mental health conditions is different than being on an order of non-hospitalization. So the way you were talking about it, I can't comment on a specific case, but someone being on probation, that's a different issue than someone being on an ONH. And so this provision would not be in effect if someone was on just probation.
I know, but the reason that he's not on probation any longer is because he wasn't competent. Okay.
And that would be triggered by the first provision.
But because he wasn't competent doesn't mean he's not a danger to other people. Correct. That's the problem. He's a danger to other people, and we're not protecting other people. Now, we can go back and forth and go on and on and on, but these are people who this person has acted out in a violent manner previously. Now that he's found incompetent, is he then free to continue to act out in a violent manner? And that's where the problem comes in. He should not be. And how do we solve that problem? United Counseling Service, obviously, not able to handle this individual. It may be more community supports, maybe wraparound. I don't know. It's not my job to figure out what it is. My job is to protect the community. That's what judiciary is about. And because he was no longer on probation or no longer in the criminal justice system, now in the mental health system, he gets a free ride to murder. That's what's wrong. And I'm really worried that if we take this section out, we lose that. Now, if the state's attorneys and the attorney general feel that we can modify this section, I'm all for that.
We do not feel that a modification is, we struggled with this just as we're struggling in the committee today with this section. Ultimately, we feel if someone's not compliant, someone needs to know about it, and it needs to be reevaluated whether an OH is appropriate or some other course of action is appropriate. Essentially, this is saying someone's not doing what they're supposed to be doing, and so we need to reevaluate the situation. So, it's imperfect, and AJ has been a great vocal supporter for public safety for as long as I've known him in these situations. But it's something that we struggled with the Attorney General and Erica and Department of Mental Health. This was the language that we ultimately decided that we could all live with, and that it would be legally sustainable.
Yeah. Thank you. Senator White's disappeared from my screen. I hope she's okay. Do other people see Senator White?
No, she's gone from the screen.
No. Hopefully she'll try and come back in soon.
Hope so. So this has been helpful discussion. If there are alternatives to the language so that somebody charged with public safety, you it's not an issue if the person's not released. It's, the DMH has that custody of that person. It's when they're on a non-hospitalization order and that is failing. There's another way of getting information. Karen, did you have thoughts or morning walks? Thoughts about better ways? Anyone?
I'm for the record, Morning Fox Deputy Commissioner for Department of Mental Health. I'm not sure I have suggestions of how to make it better at this moment. I did appreciate Attorney Rubin's, I think it was, actually, no, I think it was Senator White's suggestion of taking this language and making it a part of kind of the study committee to really kind of look at it and ensure kind of how it operates and how it does function. So I think, I agree with Attorneys Pepper and Sure as well. It's not perfect language, but it is getting us in a direction that I think we're all wanting to head towards. And I think it's important to take note of what AJ Rubin mentioned as far as notification and to what end and what would be the outcomes thereof. And I get your point, Mr. Chair, that the difference between probation or when someone's been found incompetent, that now probation is no longer an option. And so how do we weave that into, say, an order of non-hospitalization and having some of those similar notification pieces? I've testified before this committee many times about the desire to work with folks around that victim notification piece, because it has been lost on the mental health side of things. And so, like I said, I don't think this is perfect language. There's some gaps in here that, I think just will leave question on how we get notified, and to who makes the determination if a treatment is not working well. Some of those types of questions will definitely come up. But I think it's a workable piece of legislation as is. And if the committee so chose to keep the language as is, then I think it's something that's workable. It very well may get challenged in court, as Attorney Rubin mentioned, and we'd see how that plays out. If the committee felt that there's a chance that we could work on this a little bit further to avoid such a court challenge, then I would go with Senator White's suggestion of taking this language and making it part of a specific charge in the forensic study group. That group comes back with recommendations around orders of non-hospitalization and notifications related to it.
Okay. Thank you. Senator Baruth.
Thank you, Mr. Chair. I can see both sides of this argument, and I think sometimes you have to decide where the risk is greatest. So given the risks on either side, I would prefer to risk a challenge in court, which is a civil nonviolent function of government, as opposed to what we're trying to prevent. So I would be for leaving the language as it is, and maybe continuing discussions as it moves through the building, so that we could potentially change it later on in the process or next year. But I think the chair is right. Inaction on this is not an option.
Thank you. I think we can still write something into the study that has them look at this particular issue. Either Katie or Eric, if you can draft some language for us that would have the study look specifically at how DMH would get notified. And as AJ said, United Counseling Service may not let DMH know, or may not let anyone know, so then they wouldn't know. If the commissioner becomes aware, to look at, some to make sure that the forensic study committee looks at this issue, how they're going to get information to the court and to the state's attorneys or attorney general. And it may be that the alternative treatment has not been adequate to meet the person's treatment needs. And that's a little, that might be, the other body may have some alternate language there, keeping the same thing in mind.
So the forensic care working group, Senator Sears, let's have
Yeah.
them take a look at. Yep.
Yes. Well, I think it would be them. And again, this makes clear that those people who have, not everybody who's on an order or not. What's the other working group? The other is just a assessment of mental health services in the
Yeah,
direction.
I don't think it would really fit with them.
No, it really wasn't fitting there. But part of the problem is that these individuals tend to stay longer. People with mental health issues, where there's a competency evaluation needed, tend to stay longer in jail than on detention than other populations who are detained. That's what that other study tries to look at. Okay, are we good, Jen? Senator? We don't know what happened to Senator White. Hope, my guess is it's probably technical.
Should we call her?
Peggy's emailed her.
Oh, okay.
But we may try to, her internet may be out. No, this is Vermont, and this is 2021,
And
we're spending millions on internet connection, but it doesn't always work. All right. Thank you very much, AJ, and everyone else. Appreciate it. So
Thank you.
we'll work on that amendment, Eric. Maybe Thursday we can, or you just bring it to the committee.
Senator Sears, did you want to have Morning just repeat his testimony with regard to the need for the money?
Oh, I thought yes, right. Do you remember, I didn't remember your testimony about the need for 250,000 that I saw in the, I know that I heard the legal aid, but then when I saw Nolan's fiscal note, can you be more specific about the $250,000 request?
Or it's to help cover the additional costs of attorney time for actually being able to call witnesses and be a part of those hearings, similar to legal aid taking on those cases, although we wouldn't be party status, but we would take on more cases where we would be involved. And so a chunk of it is for that, as well as for the cost of examinations, further forensic evaluations.
Can I just ask?
Yeah,
I
please.
always am interested when there are round dollar amounts. Was the primary impetus for 250 because legal aid got 250 and it was just paralleling their request, or is there some calculation that supports it?
No, we did some calculations, and it's actually we actually have a range that I don't have in front of me, but we had like basically a low of approximately like 215 or 213,000 and a high of something like 285 was kind of the range of what the potential cost would be. So my testimony of the 250 was really just trying to make it a nice rounder number that kind of was in the middle of our range piece. But we actually have the actual documentation, I believe, that we provided to Nolan, but Karen can confirm that for me.
Yeah,
Okay,
I have the exact
thank you.
numbers if that's helpful.
Yes.
So on the low end for legal aid was 245. For independent evaluations, we had 120. And for DMH costs, we had 95. So that would be 460,000. On the high end, legal aid gave 265. We had 150 in there for independent evaluations and DMH at 155. So that would have been 570. So we kind of just tried to round in the middle.
Well, appropriations will look at it, probably do what they normally do and take the money out and put it in with the big bill. But, okay. Anything else on this bill before we get to S25?
A quick
Okay,
question on
thank-
the quick question on the
Yes,
amendment,
Eric.
Senator Sears. Is it I think is it on notice currently, right?
No, it's gone to appropriations.
Oh, that's right. Oh, it got referred today?
Yes.
Oh, great. Okay.
So it's on appropriations, will have to be voted out of there. So it would need to get voted on in appropriations and then come to the floor. At that time, I think we could just do an amendment to the
Yep, to the study.
study, myself and anyone else. I think at that point, it's an amendment. So myself and any other member of the committee who wanted to join in the amendment would be able to do that.
Great. Will do. Thank you.
Thank you. Any other comments on S20, on S3? We've only got like 5 minutes and Senator White's not here. So Peggy, I think we will just go offline. Oh, Michelle is here. Before we go offline, Michelle, what's your availability Thursday or Friday?
I do have some time open. I can work with Peggy to find some time. What is it that you would like to do?
I'd like to know what. At some point, somebody's going to have, Senator White hopefully has to report the marijuana bill on the floor. And when she does, hopefully we'll have added the government operations amendments, or
It's
are there more?
They're already in there. They're what you voted on Friday.
Okay. Are there any things from the Agriculture Committee?
No, as I talked about last week, their recommendation was to allow the board to proceed as you set out in Act 164, and they think they have plenty of opportunity to chime in as things move along with the system. But they felt as though they didn't have the data that they would need in order to be able to be addressing some of those issues that the agriculture witnesses brought up. And so so it'll be in finance this week. So I'm working on that, and I'm gonna address the issue of, we have that, because there's no board, and the board is supposed to report to you April 1st on its budget, on its proposed budget and its tiering and its fees, which they, can't happen. So I'll be working with Senate Finance this week on trying to find an alternative to that.
Thank you.
And I'm happy, I can work with Peggy to find some info, some time if you want me to just come in and
just
update
update
you.
us on Thursday or Friday.
Sure.
We have a very little time because of the floor change and floor schedule. All right,